Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have the latest filing here in the Justin Baldoni versus Blake Lively universe. Now, this is one of two filings that we expected to see this week from Blake Lively against Jed Wallace and Street Relations Inc. So these are the crisis PR firm that allegedly, per Blake, helped with the whole smear campaign thing to make it untraceable and all that. Jed Wallace had filed that motion to dismiss, the one where the last sentence of it had said, "It ends with us," which was like, I might have cackled at that a lot. But this is her response to his motion to dismiss. And remember, just like with Ryan's motion to dismiss, which we saw a response from Justin to Ryan's motion to dismiss last night, Ryan will be responding to that one again, and just as Jed Wallace will respond to this again. So it goes, person files motion to dismiss, other side responds, and then the initial party who filed the motion to dismiss will reply in support, and then it's fully briefed and the judge will rule on it. So we have a little bit to go in this, I'll call it a series, I guess. So this is just step 2 along the way. Let's see if she has any new information regarding Jed Wallace's supposed role in all of this. Remember that Jed Wallace had filed a lawsuit against Blake Lively in Texas, and she has until Friday to respond to that lawsuit, and I expect that she will file a motion to dismiss his lawsuit, but we'll have to wait and see. That's just, like I said, it's speculation, but that's what I expect. So, KKB, thank you for the $10. Hey, Lauren, how are you? Glad to see you immediately bringing the tea. Oh, I'm good. I was just at my mom's house with the dogs. I saw my sister for a little bit, my parents. I'm just going to give it one more minute to see if anyone wants to filter in here before we get started. I don't expect this one to take too long. It's only 30 pages, and like I said, I always skim over the case law stuff a little bit because I'm not a lawyer, as you guys know. That's why it's the court of random opinion. I'm sort of like the court of public opinion, but I don't represent everybody. It's only me, so one person's random opinion. All right. Don't forget also, tomorrow is the due date for the response to Blake Lively's motion to dismiss. So we'll have a bunch of these coming through. But yeah. Christina, hey, how's it going? How did your mom do in the race? She did good. So she was not expecting to make it to the finals, and so she did good. And then she had an outdoor race on the Saturday, and she did good in that one too, so that was good. All right. Let's go ahead and get started. Okay. Introduction and summary of argument. Jed Wallace and his company Street Relations Incorporated were the covert operatives in Justin Baldoni, Jamie Heath, and Steve Sorowitz's conspiracy to retaliate against plaintiff Blake Lively for speaking out about Mr. Baldoni and Mr. Heath's misconduct on the set of It Ends With Us. Mr. Wallace is a self-described hired gun who executes untraceable campaigns on social media platforms. In this case, despite Mr. Wallace's boasts about his clandestine abilities, he and his company got caught. Even without discovery, the facts available to Ms. Lively already show that Mr. Wallace and Street Relations joined and actively participated in the conspiracy to bury Ms. Lively and destroy her reputation in retaliation for speaking up about sexual harassment. Okay, so right out the gate here, unless they introduce some new information here, which I don't think they can do in this filing, and even if they can, I don't think they have anything to introduce. That doesn't really track. He and his company got caught even without discovery. The facts available to Miss Lively already show that Mr. Wallace joined and actively participated. In what, though? Because what we've seen from the other filings, from the other side of this lawsuit, was that, they hired the crisis PR firm, which was a responsible move given what was going on behind the scenes, the tension and all that. Also to kind of monitor what people were saying about Justin and any sort of negative stuff that might come up. He was kind of trending. What he said in his document that he was just kind of trending like what people were saying on different websites. So that's why he was saying like we're killing it on Reddit and stuff like that. Like nobody was really, to my knowledge and like my understanding of things after reading all this, it was like nobody was saying like, oh, we're crushing it, she's going down. They were just saying like, oh, we're okay, we're in the clear. Like they were trying to make sure Justin didn't get any bad press, and that's hardly a fucking crime, right? So even the thing about shining the spotlight on Blake and Ryan, which I'm sure they'll mention in here, that's still like they're doing most of the movie promotion and stuff like that because they shut Justin out of a lot of that. So he wasn't with the other cast in the promotion. So shining a spotlight on Ryan and Blake, not really, again, not a fucking crime. Like, I don't know what the problem is here. Well, I do. We have an entitled asshole who is upset about the consequences of her actions and her sorry, she's not a whore, I'm sorry. I did not mean to say that. Poor promotion of the film. I really didn't mean to say that. And so, like, she's upset about that, and so she's got to find someone else to blame for it. That's what's going on here. All right. Anyways, done with my rant there. Their co-defendants' own text messages and emails, including with Mr. Wallace, confirm that the Wallace parties knowingly joined a conspiracy designed to harm Miss Lively. Nope. Again, that's not what we saw. Okay. Knew what the conspiracy was trying to accomplish and helped that happen. The other co-conspirators could barely contain their glee at how successfully the Wallace parties executed the plan, patting themselves on the back about their amazing work. Defendants Melissa Nathan and Jennifer Abel celebrated the conspiracy's total success in achieving a shift on social, due largely to Jed and his team's effort to shift the narrative toward shining a spotlight on Blake and Ryan. Yep, which is what I just said. Again, that does not prove any sort of conspiracy theory at all. That could mean fucking anything, right? Instead of on Mr. Baldoni and Mr. Heath's misconduct. The Wallace party's efforts were so successful that Miss Nathan commented that the majority of socials are so pro-Justin and I don't even agree with half of them. LOL. And added that it's actually sad because it just shows you have people really want to hate on women. And again, I'm not thrilled with the publicists in some of these messages, but moving on. Still, these were the efforts that Miss Nathan saw as a total success, as does Justin. When another woman came forward to describe similar misconduct she experienced at the hands of Mr. Baldoni, the co-conspirators turned to the Wallace parties, with Miss Abel reporting that we flagged to Jed and his team for more serious action on the social side. Again, that's okay. Where is the proof that that was in response to another woman coming forward to describe similar misconduct? First of all, that's extremely fucking vague. And second, where's the thing connecting point A and point B here? Another woman came forward to describe similar misconduct. And then the message, we flagged to Jed for more serious action on the social side. Where's the thing connecting those two together? Because I don't see it. Maybe I'm forgetting something. Maybe I missed something. I don't know. You guys pointed out to me if I did. So, all right. The Wallace party's motion ignores all of this, along with the rest of the amended complaint, in favor of a self-serving and unsupported narrative. Well, self-awareness it's not here. I was going to try to say that in a more creative way, but it's stupid. Sorry, I don't have any special way to say it tonight. Denying any wrongdoing, any joining of a conspiracy, and any connection to New York. Each of the Wallace party's individual arguments are legally meritless and contradicted by the detailed allegations in the amended complaint, which must be taken as true for the purposes of this motion. First, the Wallace parties argue that they are not subject to personal jurisdiction in this court, but their sole argument against Miss Lively's theory of personal jurisdiction, a conspiracy-based theory, is that the Wallace parties did not join in a conspiracy. To be clear, the Wallace parties do not dispute that a conspiracy existed. This is like 5th grade bullshit. You know what I mean? Like, okay. Do not dispute that a conspiracy existed or that other members of that conspiracy established sufficient contacts with New York, but only that the Wallace parties did not join the conspiracy. Okay, if you have to, like, negate every possible thing that could be said, like, do you know how ridiculous that is? Like, I also did not dispute that a conspiracy existed, I guess. Right? Does that mean that I was in on it? Huh? Is saying, hey, by the way, I didn't fucking do that. Is that not enough? But I mean, what really? What the what? Oh my god. I still want to stay up and watch Lauren roast her live. Oh, thank you, citizen journalist. What's going on? All right. I don't know if we're there yet, KKB. Those are a little more scarce these days. I don't want it to lose its punch, you know? So I can't just be throwing that word around all the time. All right. In support of that contention, the Wallace parties rely exclusively on a self-serving declaration from Mr. Wallace himself, as most declarations would be self-serving, yes, which asserts in conclusory fashion that he did not join the conspiracy. But Mr. Wallace's self-serving declaration is contradicted by the verbatim text messages and emails in the amended complaint. At this stage, the amended complaint's more than plausible allegations trump Mr. Wallace's declaration, which the court cannot even consider at this stage without first allowing discovery into Mr. Wallace's participation in the conspiracy. Discovery that will only confirm what Miss Lively was already able to allege, based on the texts and emails she had obtained thus far. You know what I want to do? Is take all the texts that we've seen in all the filings and come up with my own list of bizarre shit that you could allege based on those texts. That could be a fun one. Okay. Second, the Wallace parties challenge venue in this court and ask for transfer to the Western District of Texas. The Wallace parties are simply incorrect that venue does not lie in this district. An argument that no other defendant has even attempted. Well, to be fair, no other defendant involved in this had sued you in Texas before you made a complaint against them. So, like, that's okay. The motion for transfer is unpersuasive. I disagree, but all right. Most importantly, the Wallace parties are wrong that the Texas lawsuit counts as first filed for purposes of the motion to transfer, simply because they were not named as defendants in this action until the amended complaint. The first filed doctrine, however, asks only whether lawsuits are substantially similar, which the Wallace parties admit is true here, not whether the parties in each case are identical. This is the first filed action, not the Wallace parties' attempt to force Miss Lively and every other witness. You gotta be kidding me. It's a litigated duplicative action in Texas. For similar reasons, the Wallace party's other arguments for transfer are unpersuasive. So, they're unpersuasive. Are you going to tell us why they're unpersuasive? Or because if that's how we play the game, if you just point the finger and be like, no, that's unpersuasive, then hello. That's fucking stupid. Cool. No explanation needed, I guess. Third, the Wallace party's limited arguments about the merits of Miss Lively's claims are all unavailing. The Wallace party's only argument against Miss Lively's false light claim is choice of law, namely that New York or Texas law should apply, rather than California law, which Miss Lively asserts. But the Wallace parties are wrong. California law applies to Miss Lively's false light claim, not least because of Mr. Wallace's own sworn admission in his declaration that he understood all of his conduct in connection with this case to constitute doing business in California. The Wallace parties are also wrong about Miss Lively's FEHA aiding and abetting claim. Sole argument is that they cannot be liable for aiding and abetting unless they knew FEHA existed and what it meant. I don't remember them saying that. I'm not saying it didn't happen, to be honest. I'm just saying I don't remember them saying that. And like these motions, the motion to dismiss, the responses, all that stuff was going like rapid fire for those 2 or 3 days. So I could just be forgetting that. I want to be clear. I'm not saying that's a lie or anything. I'm just saying I don't remember that being said. Okay. But aiding and abetting liability does not require defendants to have studied the law they are helping others to violate. only that they know about the conduct they are assisting. Finally, the Wallace party's challenges to the IIED claim are likewise meritless. One, actual malice is not a required element for Miss Lively's IIED claim, which in any event is well pled. What is that, like a pat on the back? What the hell? Good for you, buddy. And two, Miss Lively's allegations of FEHA violations are also sufficient to satisfy the outrageousness element of IIED. All right, then. Now we're going to get into the background. Give me just a second here, guys. Kirsten, thank you for the $10 super sticker. I appreciate you. I hope I said that right, Kirsten. Maybe it's Kirsten. I'm not sure. Who wrote this one? Gottlieb, Drake Sky. We'll find out at the end because I have not checked. Okay. Oh, hey, Bruce. What's going on? What the heck? What the heck? Traveler. How's it going? Sorry, sometimes I just need a break between these long paragraphs to, like, chill for a sec. Okay. All right. The Wayfarer parties embark on a conspiracy to destroy Miss Lively in retaliation for raising concerns about sexual harassment. I'm sorry, my brain can't help but go there, but if you use that as an acronym, the last 4 words there, it says retaliation for raising cash. Huh. Okay. Miss Lively's claims against the Wallace parties, like her claims against their co-defendants, ultimately trace back to Mr. Baldoni's and Mr. Heath's harassing and inappropriate behavior on the set of the film. Miss Lively raised complaints about that conduct to Mr. Baldoni, Mr. Heath, and others as early as spring 2023. She later reiterated those same concerns and others, negotiated a contract rider through which It Ends With Us movie agreed to 17, is it 17 or 30, Blake? Which one is it? Protections for the film, I know it was 17, yes. Protections for the film's return to production, and as agreed to in those protections, reiterated those concerns again to Mr. Baldoni and Mr. Heath at a January 4th all-hands meeting. Those protections included prohibitions on spontaneous improvising of intimate and sexual physical touching, simulated sex, or nudity. Prohibitions on discussions about personal sexual experiences, entering Miss Lively's trailer while she was in a state of undress. What if she makes you because you guys can't have the meeting at another time? She's like, no, just come in now. Did anyone float that scenario by her? Like, hey, Blake, maybe you shouldn't do that if you don't want them to do what you asked. And retaliation against Miss Lively for raising concerns, including during publicity and promotional work. Legal question for the lawyers when they get to it. Not facetious at all. Is it counting as retaliation if no one wants to buy your hair care line because it was completely inappropriate to the cause you were promoting to promote that and your alcohol? Just asking for a friend. All right. As the film's August 6th New York premiere neared, Mr. Baldoni and Mr. Heath grew concerned that their misconduct would become public, and in a blatant act of retaliation against Miss Lively for bringing her concerns about that misconduct through appropriate professional channels, engaged in a coordinated campaign to destroy her reputation, distract from their own behavior with false narratives about Miss Lively, and get away with their misconduct. Again, I ask, where's the connect between point A and point like B, C, D, wherever they're throwing this at? Because they grew concerned their misconduct would become public, so they blew everything up in a way that would almost certainly come back in their face. Like, that doesn't even make any sense. But also, like, what does that have to do with your reputation and, like, what false narratives? I don't see any false narratives out there except for the ones that you see everywhere on the internet because people write crazy shit on the internet all the time. That doesn't require a crisis PR firm. There's just freakish trolls everywhere. All right. As far as like the false narratives and stuff goes, it's like, it's not false narratives. It was your past behavior which came up because like people started digging into that because they didn't like something else you were doing. And that's the unfortunate name of the game when you're like a really famous person these days. All right. I remember saying that the first time I read her first complaint, the lawsuit. Because I was like, I remember a lot of this stuff from her past was coming up from like over a decade ago. And I was like, well, that doesn't really make sense to me, but dude. All right. To advance those unlawful objectives, Mr. Baldoni and Heath enlisted a number of co-conspirators, including Sarowitz, who promised to spend $100 million to ruin Miss Lively and her family's lives. And we have heard it all before, blah, blah, blah. Okay. Wayfarer Studios, it ends with this movie. Melissa Nathan and Tag, her company, the agency group, and Jennifer Abel. Mr. Baldoni and Mr. Heath shared with these co-conspirators the protections for return to production, which they styled as Miss Lively's grievances. I don't know if they're grievances so much as her imagined, retribution. I don't know. Together, the conspiracy set out to destroy Miss Lively and punish her for... This is a very paranoid filing. This is all very paranoid. It set out to destroy Miss Lively and punish her for having the courage to come forward about the harassment she and others experienced on the set of the film. Specifically on August 2nd, Miss Nathan delivered a proposal to Mr. Baldoni, which included a website to discuss, full Reddit, full social account takedowns, full social crisis team on hand for anything, engage with audiences in the right way, start threads of theories, discuss, this is the way to be fully 100% protected. Well, if you're making these threats and you're doing all these things to take over the guy's film and you're shutting him out of stuff like his own premiere, you're shutting him out of the promotion for the film, I don't blame anybody in that scenario for hiring a crisis PR team and being prepared for the worst, because clearly the worst has come out. All right. Miss Nathan also proposed the creation of social fan engagement to go back and forth with any negative accounts, helping to change the narrative and stay on track. Per Miss Nathan, all of this will be most importantly untraceable. As Miss Abel described it, the plan was to engage in social media mitigation and proactive fan posting to counter the negative as well as social manipulation. Oh boy. I mean, again, countering the negative is not the flex that they think it is in this. Somebody should have every right to defend themselves if you're like shitting on them behind the scenes and then going to take it to the press like the New York Times. To get out of this narrative, Ms. Nathan's plan proposed strategies to advance misleading counter-narratives. Okay. Misleading how? Are we supposed to take your word for it? Including pushing Miss Nathan's narrative that Miss Lively had less than favorable reputation, proposing to explore planting stories about the weaponization of feminism, and blaming Miss Lively for production members' job losses. Well, let's think about this. She did indeed have a less than favorable reputation after her own, kind of blunders in the press and the media tour surrounding the movie. Also, as we've all seen on the movie, the videos that have resurfaced, she's acted quite bitchy in some of her previous interviews, and it's coming back to bite her. See Chercy Flaw, if you don't know what I'm talking about. All right. Let's see. Proposing to explore planting stories about the weaponization of feminism. Well, you don't have to really plant anything because I'm here. I've never spoken to any of these people, and I'll tell you right now, that's what happened. They're exploiting feminism and the Me Too movement in order to punish a man who, in my opinion, seems to be pretty innocent. Maybe he is a, different kind of person that you're not used to coming across. Maybe there's some religious or cultural differences that, they didn't necessarily mesh, but he didn't do what you're accusing him of. And my firm belief is that Blake here is, in fact, exploiting and weaponizing feminism and like a social movement in order to punish someone who didn't do things the way that she wanted them to do it. So, blaming Miss Lively for production members' job losses. I've heard rumors about that, but I haven't actually seen, I don't know if I've actually seen anything in the court filings to back up that she, was the reason for anyone being fired or anything like that. I know it's been said, and I'm not saying it didn't happen. I'm just saying I can't think of anything off the top of my head that would prove that right this minute. So I'm not gonna refute it. I'm just gonna move on. All right. Initially, Mr. Baldoni expressed concerns that Tagg's written plan was insufficiently aggressive to protect him. Writing to Mr. Heath and Miss Abel, he said he was not in love with the document they sent. Not sure I'm feeling the protection I felt on the call with Miss Nathan and her colleagues. Later that day, Miss Abel and Miss Nathan exchanged more texts expressing that Mr. Baldoni wants to feel like Miss Lively can be buried. All right. I have a hard time believing that's what he said. I think maybe that they're characterizing what they felt like he wanted in their own words there, but still. Okay. I mean, it's not a crime to want to be protected when somebody's threatening your livelihood. Miss Abel and Miss Nathan agreed that they should not betray their true intentions in writing. When we send over documents, we can't send over the work we will or could do, because that could get us in a lot of trouble. We can't write it down to him. We can't write, we will destroy her. We will go to this, we will do this, we will do this, we will do this. So, I just want to say, from what I've learned about Justin, just in actually trying to find out about him as a person and his faith and what his religion entails and the way that you never see him speak bad about anybody, and that's, I think that's part of their religion is you're not supposed to speak about people like that. And I could be wrong, but I'm pretty sure I heard something like that. I'm going to say that they would get in a lot of trouble if he, who is in charge, and he is in charge of this, right? If he saw that they wrote they would destroy her, I genuinely believe that if he saw that, he would get upset. Because he seems like somebody that doesn't want anyone to disparage anyone. I've never heard the guy say anything bad about anybody. And I've been watching back their podcasts and everything, and it's just crazy. I don't know, man. I just don't believe he did it. All right. Imagine if a document saying all the things that he wants ends up in the wrong hands. Okay, so that's from their perspective. I can see that statement being a little more damning. All right, but still. Nathan followed this by assuring Miss Abel, we can bury anyone, but I can't write that to him. Mm-hmm. A few days later, Mr. Baldoni set the tone for the social combat he and his co-conspirators would enact, sending Miss Abel a thread on X that had accused another female celebrity of bullying women. Mr. Baldoni stated this is what we would need. And again, I need to look at that in context. I don't remember if they said anything about that in Justin's complaint or response or anything like that. So I want to go back and look at that. And when I do my short recap of this filing later, I will mark it and bring it up. Okay. B, the Wallace parties join and become an integral part of the conspiracy. All right. Sorry, give me 1 second. This doesn't feel like an opposition. It's just regurgitating out of context. Yeah. Out of context text that I can't believe they're still using. Yeah. Well, I don't know. We'll have to ask Omar or the two lawyers. I don't know if they actually can bring up anything new here, so I don't know if that would make a difference at all, honestly, but it does kind of seem like the same thing, All right. What did I see here? 619 views on 200 likes. Oh, thank you for reminding people to hit the like. Yes, please do. But also sometimes if you don't refresh the page, the like count doesn't go up. So it might be a little more than that. I'm not sure. Maybe not. Maybe people just don't like the video. Maybe just hit the like, please. Okay. All right. Let's see. The Wallace parties joined and become an integral part of the conspiracy. Jed and Street joined and became an integral part of the conspiracy. Mr. Wallace is a public relations consultant who has described himself as a hired gun. You can say it again, but it still doesn't matter. Jesus, they keep saying that over and over again. He describes himself as a hired gun. Okay. With a proprietary formula for defining artists and trends. Yeah. He specializes in executing confidential and untraceable campaigns on social media platforms like TikTok, Instagram, Reddit, and X to shape public perception of his clients and their adversaries, flooding the zone with their manufactured narratives. Now, maybe these people know a lot more behind the scenes than I do. Of course they do, because they're involved in this lawsuit. However, I don't think executing confidential and untraceable smear campaigns is like on his LinkedIn profile. So maybe, just maybe, you should have to prove that. I mean, I don't know. Mr. Wallace does all this through his company, Street Relations, which describes itself as a crisis mitigation firm that helps its clients navigate threats and maintains a roster of high profile and high net worth clients. One of the ways that Street serves those clients is by subcontracting with other firms to perform untraceable assignments as part of an offensive social combat strategy. I'm going to have to get somebody who works in PR on here one day to discuss this kind of stuff. If you guys have any suggestions, please let me know. Okay. Mr. Wallace had a close relationship to defendant's counsel Brian Friedman prior to this litigation. In Miss Nathan's words, very close, and had also worked with Tag and Miss Nathan before. Well, they weren't yet being sued, so I'm not sure that has anything to do with anything. You know what I mean? But, all right. Cool. Let's see. Through Tag, defendants engaged Mr. Wallace and Street in early August, when the press and public were beginning to notice none of Mr. Baldoni's fellow cast members would be seen with him. I mean, that seems like a responsible thing to do at that point. So thank you for bringing that up. Okay. Mr. Wallace and Street got to work seeding, manipulating, and advancing disparaging content on social media platforms and internet chat forums, including specific platforms that Miss Abel told Mr. Baldoni they would focus on: Reddit, TikTok, and Instagram. Cool. Miss Abel emailed Miss Nathan and Mr. Wallace on August 8th, saying to Miss Nathan and her tag team, that's catchy, I get it, about Mr. Wallace and the Street Relations team, is this something you can bring them up to speed on so they can hit the ground running? Well, golly, pack it in now, guys. Blake Lively just won this lawsuit with that. Really? Stop wasting my time. All right. On August 9th, Miss Abel, Mr. Baldoni, Mr. Heath, Miss Nathan, and other members of the tag team, I can't get over that now, tag team, exchanged text messages to celebrate the narrative that was shifting online to pointing the finger at Ryan being overly involved. Well, it does seem like Ryan was in fact overly involved. So pointing that out, again, if you don't want people to, get mad at you for it, maybe just don't do it, Ryan. It's pretty simple. All right. In response to Mr. Baldoni, a tag employee noted they had flagged to Jed and his team as well this shifting narrative. Cool. He's tracking the social media trends involving these people, so that seems, again, like the correct thing to do in this scenario. God. I'm so glad we're going through this. Okay. I am learning so much nothing. Okay. That same day, Miss Abel circulated a screenshot of a post by another woman accusing Mr. Baldoni of additional misconduct and announced that she had directed Mr. Wallace to take actions to suppress it, stating, "I'm assuming this is not true in the slightest. Either way, we flagged to Jed and his team for more serious actions on the social side." That, first of all, I'm assuming this is not true in the slightest. Thank you for including that, because makes sense. Second, either way, we flagged to Jed and his team for more serious action. That's what you should do. Oh my God. Bad press is coming his way, so they flagged it to the crisis PR team for more serious action to help with that. Oh my gosh. Call the lawyers. Call the lawyers. We have to sue them for everything. Jesus Christ. That same day, Miss Nathan reported to the group Mr. Wallace's sentiment that we are crushing it on Reddit. Well, gosh darn. They're out here celebrating good news when we're trying to ruin their lives. Better throw that in the lawsuit. I'm pissed about it. All right. Around the same time, threads began to appear on Reddit speculating about a feud between Miss Lively and Mr. Baldoni, calculated to paint Miss Lively as being in the wrong. Well, I'll tell you what, it didn't need a second coat of paint because she's clearly in the wrong. But all right. This footnote here says on August 13th, Ms. Nathan sent a text suggesting a signal thread between herself, Miss Abel, and Mr. Wallace in case you need him to connect you to Brian Friedman because they're very close. Again, look at what they're saying up here. Okay, so they're talking about a screenshot of a post by another woman accusing Mr. Baldoni of additional misconduct, which, again, I don't know who they're referring to. If someone in the chat could remind us, please, that would help me out. I'll try to pay attention to the chat for a minute. Sorry, guys. So they're saying that post was out. It was concerning. They're saying this is not true in the slightest. So we flagged it to Jed. We might need more serious action. So this guy is, in their viewpoint, being falsely accused of misconduct in already a very delicate situation because Blake and Ryan have him by the balls and they're threatening to make these false accusations to ruin his reputation and livelihood. Okay. So in case you need him to connect you to Brian Friedman, are we thinking that that is just like totally uncalled for at this point? Because somebody, maybe not even Blake, somebody is alleging misconduct that apparently didn't happen per them, assuming this is not true. Wouldn't you want a lawyer in that scenario? I mean, I feel like this is just really poorly written. Like, what the... Maybe it's just me. I don't know. But to me, it really does seem like this is a very dumb filing. I don't know, man. Not from like a law perspective, because we haven't gotten to that yet. And like, I'm not arguing law, logistics, and stuff like that. Just from like a layperson standpoint and like the narrative standpoint, I feel like this is very dumb. Like, you could be talking about anything. Auntie Ann, thank you for the 5. Sorry, I'm late. Oh, you're good. You're good. Did you bring me a pretzel? Ha, get it. All right. Anyways. On August 10th, TAG expressly acknowledged the success of the Wallace Party's efforts to shift public attention from stories about Mr. Baldoni's misconduct into a manufactured and harmful narrative about Miss Lively, stating they had started to see a shift on social, due largely to Jed and his team's efforts to shift the narrative towards shining a spotlight on Blake and Ryan. Once again, that could be referring to just about anything. And they're saying they acknowledge the success of his efforts to shift attention to Blake and Ryan, but they're saying they're acknowledging that they shifted attention into a manufactured and harmful narrative. There's, again, no string connecting point A and point B here. You're like seeing what you want to see or something. I don't know. And guys, if more texts and stuff come out in evidence and I read that and I'm like, oh shit, I was wrong. I'll say it. I'll be like, yeah, I was wrong. But right here, right now, I'm not seeing it. Okay. Following this shift, Miss Nathan texted, the majority of socials are so pro-Justin, and I don't even agree with half of them. Miss Nathan later bragged that this went so well, it was genius. Again, context, please. Over the days that followed, Mr. Wallace and Street led a digital team that worked with Miss Nathan, Miss Abel, and TAG to further implement their social manipulation strategy. When an allegation surfaced regarding additional misconduct by Mr. Baldoni, as Miss Abel stated, this girl is claiming that Justin invited her up to his hotel room years ago. Oh, is that what we were talking about before? Miss Nathan advised Miss Abel, let us chat to Jed as well on this. In response to Mr. Baldoni's concern that he did not want bots defending him online, I really don't want bots defending me. Well, I'm not a bot, man. I'm still here. All right. Miss Nathan reassured him that something much more sophisticated was in motion, stating that the other team, a reference to the Wallace parties, is doing something very specific in terms of what they do. You know what's not very specific? This filing. Adding that I know Jamie and Jed connected on this. Okay. The Wallace parties sue in California, dismiss that action, then sue Miss Lively in Texas after learning that this action would proceed in New York. Well, they weren't. I mean, again, that's something the lawyers could probably speak on better than me, but they weren't named in the New York lawsuit. So, like, Blake filed her lawsuit and did not name them in it. So, what? Okay. Anyways, that was her choice. It was her choice not to name them in it. On December 20th, Ms. Lively filed an administrative complaint with the California Civil Rights Department, which included all of the allegations set forth above in Section A. The CRD complaint asserted facts supporting 10 claims under California law, including sexual harassment, retaliation, failure to prevent harassment and retaliation, aiding and abetting the same, as well as others. Okay. On December 31st, the Wayfarer parties, including Mr. Wallace, sued the New York Times for defamation in California State Court. Okay. Arising out of an article it wrote covering Miss Lively's CRD complaint entitled "We Can Bury Anyone" inside a Hollywood smear campaign. On January 16th, Wayfarer, but not Mr. Wallace, sued Miss Lively and others in this court and then dismissed the California state case. Yeah. Okay. At the February 3rd initial conference in this matter, Brian Friedman, who had represented the Wallace parties in connection with their California lawsuit, explained that the Wayfarer parties had filed in this court because it made no sense to be doing this on different coasts and with different courts. And since so many of the issues are going to be so similar, that to have it all in one proceeding in front of this court would make the most sense. The very next day, the Wallace parties sued Miss Lively in the Western District of Texas, asserting causes of action for 1, a declaratory judgment that the Wallace parties were not liable for conduct alleged in the CRD, and 2, defamation based on the idea that Miss Lively had defamed them by including their names in the caption of her CRD complaint. No, I mean, you also name them in the New York Times article, right? So like you gave all that information to the New York Times, was like, here, put this out into the universe. I don't know if that matters at all. We'll have to ask the lawyers, but all right. Okay. Again, no, I'm not seeing what this has to do with the fact that she did not name him in the lawsuit, right? So February 3rd conference happens. Jed Wallace is not a part of that. Jed Wallace sues her separately in Texas. And? Okay. There, the Wallace parties allege that Street Relations is a corporation organized under the laws of the state of California. Huh. On February 18th, Miss Lively amended her complaint in this action to add the Wallace parties. Okay. The amended complaint is substantially similar to the CRD complaint, including that it names Wallace and Street Relations as members of the conspiracy. Okay, but your initial complaint did not. He was not part of this action, and then you added him after he sued you. Again, we'll have to ask the lawyers. I don't know if that, from a legal, perspective, what that means, but from just a layperson standpoint, just a human standpoint, get over yourself, dude. Like, you didn't sue him. He sued you, and then you were like, oh no, well, I was going to sue him first. Like, okay. Why didn't you just do it, All right. Legal standard. And this is where I'm going to start to skim through a little bit, guys. Okay. In reviewing a motion to dismiss, the court accepts all factual allegations as true and draws all reasonable inferences in plaintiff's favor. Similarly, on a Rule 12b2 motion to dismiss for lack of personal jurisdiction, whereas here discovery has not yet been conducted, the court assumes the truth of the plaintiff's factual allegations for purposes of the motion. Okay. Argument 1. This court has personal jurisdiction over the Wallace parties under a conspiracy theory of jurisdiction. So many conspiracy theories. As the Wallace parties concede, all that is necessary to establish personal jurisdiction at this stage is for Miss Lively to allege 1. That a conspiracy existed, 2. That the Wallace parties participated in the conspiracy, and 3. That a co-conspirator's overt acts in furtherance of the conspiracy had sufficient contacts with New York to subject that co-conspirator to jurisdiction in that state. The Wallace parties do not dispute that the first and third requirements are satisfied. Wallace expresses doubts that the Wayfarer party's conspiracy existed, but does not dispute that the amended complaint sufficiently alleges such a conspiracy. Jesus Christ. Nor do the Wallace parties dispute that individual members of the conspiracy committed overt acts with sufficient contacts with New York to subject them to jurisdiction in New York. Hold on. Okay, so they're talking about other members. Okay. Instead, the Wallace party's sole argument against the conspiracy theory of jurisdiction is to assert that Wallace was not involved in the conspiracy. To support that assertion, the Wallace parties ignore the amended complaint entirely, relying solely on Wallace's self-serving declaration. But at this stage, on a Rule 12b2 motion, where no jurisdictional discovery has been conducted, Wallace's declaration is irrelevant to the personal jurisdiction analysis. Instead, whereas here, jurisdictional discovery has not been conducted, to defeat a motion to dismiss, the plaintiff need only put forth legally sufficient allegations of jurisdiction. Okay. The amended complaint more than sufficiently alleges the Wallace party's agreement to participate in the conspiracy alleged in the amended complaint. I don't know if I necessarily agree with that, but all right. During the crucial period surrounding the August 2024 premiere of the film, at which Mr. Sarowitz pledged to spend $100 million to ruin the lives of Miss Lively and her family, they're really mad about that. They keep bringing it up where it really doesn't make sense to bring it up, but okay. Ms. Nathan, Ms. Abel, and Tag began to fulfill Mr. Sarowitz's threat, engaging Mr. Wallace in street relations to design and implement a social combat plan. I'm pretty sure, didn't he pledge to spend $100 million to basically defend them, not to ruin people's lives? I don't know, man. I don't think that his alleged statements were in writing. I think that they just said this is what he said. At least that's, as far as I know, that's what happened. But I'm gonna have to double check that. All right. Mr. Wallace and street relations were in close communication with Miss Nathan and Miss Abel, receiving instructions on how to perform their role in the conspiracy. Okay. If somebody was really this good at untraceable smear campaigns, do you think that they would just type all this out in very easily obtainable text messages? Like he's supposed to be some kind of evil genius of smear campaigns and social conspiracies and shit like that. And then he's just texting about what they're doing. I don't think so, man. That doesn't make sense to me. Okay. Receiving credit from their satisfied co-conspirators for their efforts. Oh, man. Taken as true, these allegations establish that the Wallace parties were full members of the conspiracy, which defeats the Wallace party's sole challenge to a conspiracy-based theory of jurisdiction. Alternatively, if there's any doubt as to personal jurisdiction of the Wallace parties, the court should order jurisdictional discovery. Further, because the sole jurisdictional issue, whether the Wallace parties were members of the conspiracy, is interwoven with the underlying merits. Okay. Without discovery into the merits issues raised by Wallace parties, Miss Lively has no ability to test those arguments, including the unsupported assertions of Mr. Wallace's declaration. And because discovery is already underway, The most efficient course would be for jurisdictional discovery to proceed as a component of merits discovery. Okay. Chad, please explain my role and how to embark on this conspiracy. Maybe he'll just text you about it, since he's that careless, apparently, even though he's supposed to be a genius. Okay. Totally being sarcastic. Okay. The Wallace party's venue arguments are meritless. Not you talking about meritless. After everything you just wrote. All right. So I'm going to skim over this. Yeah. The film itself premiered in Manhattan, and it was at that premiere that Mr. Sarowitz announced that he was prepared to spend $100 million. You're really mad about that. And I doubt that he said exactly that, but okay. He was prepared to spend $100 million to ruin Miss Lively and her family's lives. Well, gee. I love when like people will bring up like they have kids and stuff like that. I'm like, so does Justin and his wife. Like, no, you don't get to play that card. All right. Mr. Baldoni and Mr. Heath, as officers of Wayfair, also engaged with Jonesworks, a company with its principal place of business in New York. An engagement that initiated the retaliation campaign at issue. I don't know about that. On the day of the film's release, Miss Nathan communicated with her sister, a journalist at the New York Post and contributor at Page 6, to shape her sister's coverage of Miss Lively in the Post. Well, we've seen those communications, and that's not exactly what happened, but okay. Miss Sarah Nathan continued to correspond with Miss Abel Miss Nathan, even exchanging drafts of a story pushing the Wayfair party's narrative about Miss Lively's role in editing the film. What does that have to do with Jed Wallace? Like she read her sister's drafts of her story, I guess, allegedly. Okay, moving on. These events are more than substantial enough to satisfy Section 1391b2. Even where defendants may not have been physically present in New York in carrying out the alleged scheme, that is not necessarily relevant to the issue of whether a substantial part of the events or omissions giving rise to the claim occurred in New York. Okay. The motion to sever the Wallace parties and transfer venue should be denied. 1, the first to file rule favors this action, not the Texas action. So I'm going to skim over a lot of this stuff because it's just related to jurisdiction, and we already read a lot of what they had to say about that, and especially with the case law stuff. That's going to be something that Omar and the two lawyers and Cassidy O'Connell, I'm sure they'll go over that stuff. Okay. According to the Wallace parties, the only reason the Texas action qualifies as first filed, rather than this one, is that they were not named in this action until 2 weeks after the Texas action was filed. But that difference is insufficient to render the Texas action first filed. Instead, this action, which was filed on December 31st, is the first filed action. But you didn't... Okay. He was not a party in the action filed on December 31st. Okay. We basically read the same thing in the beginning paragraph, so I won't go through that. Motion to transfer should be denied. Wallace parties have not carried their burden to show transfer is warranted. Okay. Okay. Yeah, I'm going to skim over that. Yeah, this is all mostly to do with the jurisdiction stuff. Okay, 3. The motion to dismiss should be denied. A. The Wallace defendant's sole objection to the false light claim that New York or Texas law must apply to it is meritless. The Wallace party's sole argument for dismissal of Miss Lively's false light claim is that New York or Texas law applies rather than California law. That argument fails. The totality of the Wallace party's argument against application of California law is that under Lively's theory of venue and personal jurisdiction, New York is the epicenter of this case, and therefore ruling in Miss Lively's favor on those issues involves necessarily accepting her theory that New York has the most significant relationship to the claims and certainly to the exclusion of California, where no conduct is alleged to have taken place. That is wrong twice over. First, the Wallace party's argument that if personal jurisdiction and venue are proper in New York choice of law principles consequently mandate the application of New York law is simply a non sequitur. Accepting that logic would render the entire doctrine of conflict of laws meaningless, because answering threshold questions on personal jurisdiction and venue inquiries would necessarily dictate the answer to choice of law. Applying that standard to the amended complaint reveals the deeper problem with the Wallace party's argument. Their citation-free assertion that no conduct is alleged to have taken place in California. But that assertion is demonstrably false. The Wallace parties conveniently omit that throughout the period that is the subject of the amended complaint, street relations was incorporated in California. Worse yet, this argument is belied by Mr. Wallace's declaration, in which he confirms that he understood his own conduct in connection with the Wayfarer party's conspiracy to be directed at California and exclusively California. Okay. And they're quoting Wallace's declaration here. It says, because I provided feedback to Miss Nathan, who I understood to be in California most, if not all the time, I only considered the impact of my work to be in California. The goal of my work was to inform her and her team, who I anticipated would be in California, and I thought of her work as for Wayfarer Studios, which I knew and know to be based in California. In other words, I thought I was doing business and providing my services to individuals in California. Okay. That's definitely going to be a question for the lawyers. The lawyers who stream about this case, because when the jurisdiction stuff comes into play, there's a lot that I don't necessarily understand, so I won't comment too much on that. Lauren, get Ariana Grande on the phone. We need to talk about this donut? What donut? Oh, the donut shop she was at, yeah. Huh. I forgot that existed, but thanks for the reminder, I guess, Bruce. All right. California's interest in regulating the Wallace party's conduct becomes even clearer when viewed in light of the fact that in this action, Miss Lively seeks to impose at minimum vicarious liability on the Wallace parties for their participation in a conspiracy to commit the tort of false light against her. The Wallace parties do not meaningfully dispute that the primary tortfeasor's conduct in committing that underlying tort is governed by California law, nor could they for several reasons. Those tortfeasors engaged in a substantial amount of tortious conduct in California, where they themselves, principally California residents or California entities, and in the case of the Wayfarer defendants, were bound by a contractual choice of law provision that encompasses related torts, including Miss Lively's false light claim. By joining the conspiracy, the Wallace parties became vicariously liable for their co-conspirators' commission of that California law tort. Okay. B, the Wallace defendants' attempt to plead ignorance of the law is no excuse for their knowing, aiding, and abetting of retaliatory conduct that violated FEHA. The Wallace parties do not dispute that California law applies to Miss Lively's FEHA aiding and abetting claim. Instead, they advance two related arguments under California's law. First, that Miss Lively has not adequately alleged the knowledge element of the claim, and second, that all of the relevant primary conduct occurred prior to the Wallace parties' aiding and abetting began. Both arguments are meritless. Okay. FEHA makes it unlawful for any person to aid, abet, incite, compel, or coerce the doing of any of the acts forbidden under the Act, or to attempt to do so. The totality of the Wallace party's argument challenges the amended complaint's allegations as to that element, asserting that Miss Lively has not alleged how or why Wallace Street knew that the FEHA existed, let alone that anyone's conduct violated it in this case. But aiding and abetting liability does not require that degree of knowledge. In particular, it does not require that the defendant subjectively know the law, much less hold a correct interpretation of the law. All that is necessary is that the defendant subjectively know of facts that, properly and objectively understood, constitute a violation. The Wallace party's contrary rule would be absurd. A defendant could not be held liable on aiding and abetting theory without an allegation that he or she had arrived at or obtained a legal opinion about their collaborator's conduct. The law does not require that the Wallace parties knew that the FEHA existed or Googled it or fired up Westlaw or asked ChatGPT whether it was unlawful to retaliate against someone for speaking up about harassment at work. Okay, but hear me out. What if there wasn't really any harassment because she lied? In order to be liable for aiding and abetting. All right. Is this a rough? Hey, Zach, what's going on? Here, the amended complaint demonstrates that the Wallace parties knew that the Wayfarer parties were retaliating against Miss Lively for engaging in conduct protected by FEHA. What filing were you reading? What? Okay, indeed, the whole point of retaining the Wallace parties was so that they could help the Wayfarer parties shift the narrative from HR complaints on set to shining a spotlight on Miss Lively instead, in an effort to destroy her reputation. What HR complaints on set? I'll give you a minute to answer that one. No, I think that's really irritating because obviously Sony has said there were no complaints. Why were no complaints made to Sony? And apparently, no one else has seen any complaints. So, and she didn't go to her union, which she could have done. So no reports were made. Why are you still lying about this? Okay. During this process, Miss Abel and Miss Nathan, acting on behalf of the Wayfarer parties, flagged social media accounts questioning Mr. Baldoni's misconduct to Mr. Wallace. Again, a responsible thing to do. Directing Mr. Wallace to take serious actions on the social side in response. These actions occurred after the Wayfarer team had begun to receive inquiries from the press about HR complaints made regarding Mr. Baldoni and Mr. Heath's behavior on the set of the film, and works to suppress coverage of those complaints. What complaints? Also, again, if you're getting inquiries like that, of course you want help from Crisis PR. Jesus Christ. Like, what? Why do these people arrive at the conclusion it has to be a conspiracy, dude? Like, no, it doesn't. All right. Those allegations and the inferences they support are more than enough to establish that the Wallace parties knew that the purpose of their work in shifting the narrative against Miss Lively was in response to the concerns that she raised about Mr. Baldoni and Mr. Heath's harassing and inappropriate behavior. Knowledge of those facts equates to knowledge of an FEHA violation. Again, response to the concerns she raised about Mr. Baldoni and Mr. Heath's harassing and inappropriate behavior. The problem here is that there was, no discernible harassing or inappropriate behavior to speak of. I mean, Jesus, the way they frame some of this stuff is ridiculous. Knowledge of those facts equates knowledge of the violation. Okay, for these same reasons, the Wallace party's second argument against the FEHA retaliation claim fails. Okay. One intended to destroy Miss Lively's reputation. Like, guys, if I had done some dumb shit when I was like in my late teens, like adulthood or 20s or something, like wear blackface or something. And then people brought that up and they were like, she's a bad person. Is that a conspiracy to destroy my reputation then? Which, by the way, I never did that. That did not happen, okay? I'm just trying to come up with an example of some stuff that she allegedly has done in the past. Is that a conspiracy then to destroy my reputation? Or is it just people criticizing my own bad behavior from the past? I would never do something like that, but, you know. I've done some weird things for sure. So people that, if people ever were to uncover stuff about me, it would just be kind of strange and be like, do you really want to hang out with that person? Not, oh, she's terrible. So maybe it's a little different, but still, that would be the fault of my own. And it would be my responsibility to fix my reputation at that point because people didn't like what I did. But I guess I could just file a lawsuit instead. Okay. The Wallace defendant's objections to the IIED claim are meritless, and that's intentional infliction of emotional distress. Okay. The Wallace parties argue that Ms. Lively has failed to plead a sufficient claim for intentional infliction of emotional distress because she has failed to sufficiently allege actual malice, and because the alleged conduct cannot possibly amount to the requisite outrageousness for a viable claim. Neither argument is correct. At the outset, the Wallace parties are incorrect that the actual malice standard even applies. The actual malice standard applies where an IIED claim rests exclusively on a theory for what has been determined to be a constitutionally protected publication. This footnote here, I'm going to read some of this because it looks like they have some specific stuff in there. Okay. Notably, Mr. Baldoni has confessed to the elements of the FVHA retaliation claim that the Wallace parties aided and abetted, because Mr. Baldoni has admitted that Ms. Lively genuinely believes she's right, a statement with which Ms. Nathan fully agreed. She fully does, I know it. What? How is that a confession to any wrongdoing? Like, that's just straight up make-believe. Like, what are you talking about? All right. As is well established, a retaliation claim may be brought, and this is, same footnote. Retaliation claim may be brought by an employee who has complained of or opposed conduct that the employee reasonably believes to be discriminatory. What if the opposed conduct didn't happen and the person made it up out of thin air? Or what if they invited you into, what if she invited you into her trailer and was like, we have to have this meeting now while I'm breastfeeding, and then was like, sign this document later that says you won't come into my trailer when I'm breastfeeding anymore, or I'm going to ruin your life. I mean, okay. Public figures and public officials may not recover for the tort of intentional infliction of emotional distress by reason of publications without proving actual malice, but as applicable here, IIED claims may stand independent of reputational claims where they consist of far more than publications. All right. Ms. Lively's IIED claim as to the Wallace parties extends beyond a gravamen of falsehoods. As detailed in the amended complaint, the conduct giving rise to Ms. Lively's IIED was multifaceted and included soliciting, developing, implementing, and promoting a covert multi-tiered press and digital plan. The Wallace parties were at the core of the covert multi-tiered digital plan, pursuant to which they weaponized a digital army around the country from New York to Los Angeles and beyond to create, seed, promote, and engage with content that appeared to be authentic on social media platforms and internet chat forums. Dude, what exactly are you talking about, though? Because again, if it's just your past behavior coming back to light, that happens to so many celebrities. Like, it's like constant. It happens to fucking Bachelor contestants on a regular basis. You think you aren't going to have your past dug into if you show up to promote a film about domestic violence and you're all, drink my Betty Buzz. Ooh, hair care. I mean, maybe that was a little bit exaggerated, but you know what I mean. All right. This is a Hollywood thing to be this unaware of yourself at the most basic of levels. Last I checked, most folks don't think someone who does blackface equals a good person. I don't know, dude. I remember her saying she like dressed up like a, what was it? Hang on. Yeah, it was the blackface thing. So she said, I once dressed up as a black girl to stalk a guy I was into. So yeah, that's not at all creepy and possibly contributing to your poor reputation, is it? No. No. Of course not. Of course not. Okay. It was to stalk boys. Yes, that makes it better. I know that's not what you're saying, but still. All right. Amplifying negative content about Miss Lively, including through engagement via comments on social media. No, honey, those were my comments. I said I thought you were a... You know what? I'm not going to use the word. I'm not going to use the word tonight. A grunt. Something that rhymes with it. I'm not fired up enough tonight to say the word. We'll see. I don't want it to lose its... You know... I don't want it to lose its sharpness. So, all right. And suppressing of negative content about Mr. Baldoni, as one would want to do if you're falsely being accused of misconduct. But thanks for that. Because the Wallace Party's digital weaponization and social algorithm manipulation are separate from the injurious falsehoods aimed at Miss Lively, actual malice is not required. Okay. The Wallace parties admit that the amended complaint alleges actual malice in connection with Miss Lively's false light claim, that defendants knew the public disclosures would create a false impression about Miss Lively, or acted with reckless disregard for the truth. The amended complaint further demonstrates that Mr. Wallace and Street Relations knew, or recklessly disregarded, that their conduct would create a false impression about Miss Lively. Okay. 1. A strategic plan was concocted in response to Miss Lively's grievances and to get ahead of the narrative. Well, yes, I too would want to get ahead of the narrative if I knew a psycho was about to blow up my life. But okay. 2. TAG identified the Wallace parties as one of 2 digital teams to orchestrate their online narrative. Is that exactly what they said? What narrative? You could be talking about the very hungry caterpillar, for all I know. The words used here are just, they're not satisfying me. Okay. Let's see. And 3, TAG brought Mr. Wallace and his team up to speed by August 8th. All right. From that point, Mr. Wallace took aim at Miss Lively, casting her in a false light as to her marketing decisions, moral character, private life, and family, starting threads of theories and seeding social media accounts. I'm just like, she's probably just like seething, scrolling through Reddit and being like, oh my gosh, how dare these people talk about shit I said when I was 20. Yeah, I did that, but still, you weren't supposed to know about it. Jesus Christ, man. Okay. All right. I can do this. Okay. And seeding social media content on online chat. Oh, it is Reddit. On online chat sites like Reddit. God bless Reddit. What a cesspool. And I am a member of that community. I mean, not the one that they're referring to. I just mean Reddit in general. I'm on Reddit, yeah. But my Reddit name is Wentworth Bandit. If anyone sees me on there, say hi. All right. Let's see, starting threads of theories and seeding social media content on online chat sites like Reddit that help create and sustain a negative news cycle and social media algorithm around Miss Lively. Gosh, I don't know, guys. I thought it was Mommy Sleuths, but apparently it was Jed Wallace, some dude in Texas. Somebody ask Glamour Magazine, because that's where you go to get all your reputable news, huh? All right. And long after, the co-conspirators continued to create the impression that Miss Lively fabricated sexual harassment claims to seize control of the film, which they knew to be false. No. No. Sorry. I mean, you don't get to just, I mean, I guess you technically can say that, but you don't get to force people to accept that this is a credible statement at all, because honestly, it does seem like she fabricated sexual harassment claims to seize control of the film. So, big yikes. All right. The Wallace parties cannot credibly argue that their conduct was not extreme and outrageous. Well, that remains to be seen. The primary argument for this proposition is that it is hard to imagine how a public relations point/counterpoint could be a cognizable IED claim. To be clear, working to bury and destroy someone who raises claims of sexual harassment is not a PR counterpoint. Well, no, but since no one was sexually harassed here. Okay. On the contrary, the amended complaint exhaustively details the outrageous nature of the retaliatory scheme in which the Wallace parties participated, including the seeding of content that created and sustained a negative news cycle and social media algorithm around Miss Lively, and that resulted in online vitriol and violence. Really? Violence inundating Miss Lively, her business accounts, and her loved ones. See, for example, and there's paragraphs in the amended complaint that they cited, but to my recollection in the amended complaint, people said violent things to Miss Lively. They did not show any examples or explain what they meant by that or anything, but okay. Or maybe that was a different motion, man. I don't know. I'll go back and double check. The Wallace party's actions here fall squarely within the outrageous conduct recognized by the California courts that gives rise to an IAED claim. Okay. The outrageousness of... Stop saying outrageous! Sorry. It's losing its bite. The outrageousness of such conduct is particularly striking given, as described above, the Wallace party's participation in the retaliatory astroturfing campaign in direct violation of the FEHA. Such discriminatory conduct is plainly outrageous. Okay. The motion to dismiss and transfer should be denied. Who wrote this one? Gottlieb did. Okay. Well, like I said, I really feel like that was very stupid. I'm sorry. I really feel like most, if not all, of that was very stupid, but we'll have to wait and see. Ricardo, hi, I'm late. Wrestling was on. Hi, people. Thank you very much for the $2. And also, hi. But hang on, let me see if anything came up while we were doing that. Give me 1 second. Not on this one. Okay. Now let me check one more of these to make sure there's no other things that came up on the docket while we were reading that, because that happened to me once and I was like, oh God, I'm flustered. Okay. Yeah, not yet. Okay. So probably tomorrow then. But next time we see anything. Remember, the response to Blake's motion to dismiss is due tomorrow, so we'll be covering that. Amanda Sherbert, thank you for the $3 super sticker. I appreciate you. And I like your last name. That's very cool. Sherbert. All right. Guys, who's talking about hairy muffins in my chat right now? And please tell me that's not a euphemism. All right. 1 sec here. Guys, do me a favor. Don't forget to hit the like on this video. It really helps out my channel. I'm going to be prepared to cover everything else that comes out in the next couple days. So, yeah, just stay tuned. And like I said, I'll have a little short recap of this filing that I'll put out tomorrow morning, like I did this morning with last night's filing. So, all right. I'm going to send you guys over to the baby goat cam. Please tell my friend Valhalla I said hello. and that Lauren sent you. I have to go now because I don't know if you couldn't, tell or could tell, but I have to pee. I have to pee so bad. Okay, so I'm going to see you guys tomorrow. Leave a comment, leave a like, and I will talk to you soon. Bye.